Quantum computing is no longer science fiction, it's legally urgent science. Is the law ready to face a technology that could break the security systems we consider unbreakable today? I'm Jose Ramirez, and in this video, we'll explore the impact of quantum computing on our legal systems. In 2025, several technological powers have announced concrete advances in quantum computers with processing capacity millions of times greater than any current supercomputer. Companies like IBM, Google, and centers in China have managed to process complex problems in seconds, but this raises an urgent concern. Encryption systems, which support everything from digital signatures to personal data and banking transfers, could become vulnerable to this new level of computational power. Today, we will analyze what is quantum computing and why does it challenge the legal framework? What does Ecuadorian regulations say about information security and emerging technologies? And what are the legal risks and opportunities we must anticipate now? Quantum computing doesn't follow the binary rules of classical systems. It uses qubits, which can be in multiple states at once, allowing information to be processed in parallel and at previously unimaginable speeds. The problem is that this capacity could make current encryption systems like RSA or AES obsolete, as they are based on the difficulty of certain mathematical calculations. This threatens the confidentiality, integrity, and authenticity of digital documents, smart contracts, and protected data. The Organic Law on Personal Data Protection, in force since 2021, along with its 2023 regulation, requires data controllers to implement technical and organizational measures to ensure information security. However, it does not address quantum scenarios or risks arising from this new paradigm. The Commercial Code and the Comprehensive Organic Criminal Code also recognize digital evidence and cybercrimes, but they lack specific provisions to protect information against quantum attacks. This suggests an urgent need for regulation to adapt our laws by incorporating the principle of technological precaution and to promote research in post-quantum cybersecurity. Challenges: the need to update protocols for electronic signatures and blockchain, review of legal frameworks for professional secrecy, digital evidence, custody, and cybercrime, redefining legal liability for failures in quantum information protection. Opportunities: a push for a regulatory framework for responsible technological innovation, promotion of public-private partnerships in advanced crypto security, positioning Ecuador as a regional leader in the law of emerging technologies. Quantum computing could be the great legal disruptor of the next decade. We can't stay with a legal framework built for a binary world where reality is already entering the quantum era. At In Solidum Lawyers, we believe anticipating change is part of good legal practice. The question is no longer if this technology will impact the law, but when it will, and whether we will be ready to respond. If you found this analysis useful, subscribe to the In Solidum Lawyers channel, leave your questions in the comments, and share this video with those building the law of tomorrow. Here, we analyze the present with a vision for the future.